It takes extraordinary courage for them to stand up here and retell the story.
Anti-gunners put in there to keep the guns out of the hands of lawful citizens in New York State.
To actually make laws without congressional approval. They're really there to enforce laws.
Blatantly denying the power grab being carried out by the executive branch yet again.
Affect us here, and it was such a breath of fresh air for the Second Amendment people.
Brace that this letter was responsive to. Are you telling me that this brace is exempt from your rule?
Great news! In its recent decision in the Mock versus Garland ATF pistol brace case, the Fifth Circuit concluded that the ATF's rule regarding pistol braces was in fact unconstitutional and decided against the ATF as a result. Errors in Mock versus Garland case. The most recent ATF pistol brace rule judgment by Fisker may have shed light on the fact that the district court in the Mock versus Garland case made a mistake. In the case of Mock versus Garland, the plaintiffs asked for a preliminary injunction, but Judge Reed O'Connor of the Federal District Court dismissed their request. Judge O'Connor wrote in that opinion that the court concludes that the plaintiffs had not satisfied their burden to demonstrate that they have significant rights. The pro side has achieved a big triumph here, while the ATF has suffered another significant loss as a result of this development. In the judgment, Judge O'Connor stated his opinion that he believed the ATF's application of the pistol brace rule was likely within its legislative jurisdiction and did not violate the APA. Connor wrote that he believed this to be the case. After making that decision, FBC later appealed the matter to the Fifth Circuit on an interlocutory basis. They maintained that Judge O'Connor had exceeded his power in denying their initial request for a preliminary injunction, and that the Fifth Circuit Court of Appeals had made an error in denying their appeal of that decision. Additionally, the plaintiffs, the FBC, and the members of both organizations were granted a temporary injunction by the Fifth Circuit panel, which put an immediate end to the pistol brace rule. This injunction was very important, and it continues to apply to a large number of persons, including FBC and the members of their organization. Following it, there were a plethora of other lawsuits that were filed, all of which were of critical importance. In the interim, we found out that the Fifth Circuit Court of Appeals had finally made a ruling in the Mock case after hearing the case, and the judgment was rendered in a manner that was unfavorable to the ATF.
To actually make laws without congressional approval. They're really there to enforce laws.
Blatantly denying the power grab being carried out by the executive branch yet again.
The uptick in violence has just been astronomical. The gun violence.
As a kid, I came out of a different movement, the civil rights movement.
Who showed up here said one thing that felt good about doing this kind of event was that they felt empowered.
The Fifth Circuit has ruled that the GOA case and the SAF case also sought similar injunctions, and in the end, the courts who presided over those cases granted limited injunctions that safeguarded those organizations and their members, at least until the Fifth Circuit decided to rule in the Mock case. The Fifth Circuit has found that the GOA case and the SAF case similarly sought similar injunctions. The court mentioned in its ruling that the ATF is incorrectly claiming that the final rule is primarily interpretive rather than legislative, and as a consequence, is exempt from the logical outgrowth test. The court's reasoning for this assertion was that the ATF should know better. The final regulation is subject to the logical outgrowth test, which determines whether or not a rule has legislative intent based on whether or not it significantly implicates private interests or affects individual rights with the force of law. Because there is almost no similarity between the proposed rule and the final regulation, it does not pass the logical outgrowth test and is not in compliance with the APA. This is noteworthy because the Fifth Circuit asserts that the measures taken by the ATF were in violation of the APA and exceeded the scope of what they were authorized to accomplish. Fifth Circuit rejects ATF's claim on pistol brace rule. The Fifth Circuit also rejected the ATF's assertion that the pistol brace rule is purely interpretive and instead agreed with FBC that the pistol brace rule is legislative in substance. This decision came after the ATF argued that the rule was simply interpretive. Due to the fact that it was a legislative matter, the fact that the ATF discarded worksheet 49.99 in the proposed rule and then inserted an entirely new rule in the final version implies that the ATF must fail the illogical outgrowth test.
Pretty clear about the extent to which This is an abuse of the Administrative Procedures Act.
Is it a difficult question to understand?
I'm sure it's enormously high. It's 36 per 100,000 people.
I just felt that I needed to be able to protect myself.
The illogical outgrowth test, in its most basic form, is used to establish when a government agency is permitted to create a rule that is distinct in some respects from the rule that was initially suggested. A sufficient amount of notice of the modifications from the proposed rule to the final rule is considered to have been provided according to the criteria, if the changes are consistent with the general framework of the rule from the beginning. The contention made in this instance is that the ATF is unable to pass the logical outgrowth test due to the fact that they have substantially shifted their approach from the proposed regulation, which included worksheet 49.99. They moved it from the worksheet to the final rule, which consisted of only 6 hazy requirements that were completely subjective and gave the ATF a great deal of discretion. Therefore, the Fifth Circuit agrees with FBC that the ATF should have lost at the preliminary injunction stage, at least on the APA grounds. This means that the Fifth Circuit upholds FBC's original ruling. The Fifth Circuit continues by stating that the current case is not the only one involving a challenge to the final rule in its subsequent statement. In addition to the injunction that was handed down initially by this judge, multiple other judges within the circuit have already granted injunctions against the final regulation, preventing it from being enforced against members of various gun rights organizations. In addition to this, it is not yet known how many people are already bound by these injunctions, or how the ATF intends to enforce the final rule against parties who have not been ordered to do so. It is important that the law be applied in a consistent manner, yet it is possible that this court does not have all of the necessary data. As a consequence of this, the district court is in a better position to evaluate the evidence and manufacture the remedy that is most suitable. The order that was previously made that denied a preliminary injunction has been reversed by the Fifth Circuit Court of Appeals and remanded with the directive to evaluate the motion as quickly as possible to ensure its trustworthiness. Following the clarification provided by the Merits Panel on May 26, 2023, the court has decided to keep the provisional injunction that was issued by the Motions Panel on May 23, 2023, pending appeal.
Because he doesn't care about separation of powers either.
The Texas House of Representatives just voted to impeach Texas Attorney General Ken Paxton.
How many guns has the ATF lost? I'm not sure I understand the question.
It will shoot, then it comes back forward. The rifle will then cycle and cock again.
The extent to which this is an unconstitutional violation of our Second Amendment rights. But what is also true is that it is incumbent upon the United States Congress, the House of Representatives in particular.
Wime says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
The injunction issued by the court will be null and void 60 days after the date of this decision, or as soon as the district court makes a ruling on a preliminary injunction, depending on which event basically takes place first. The court orders the district court to make a decision within the next 60 days. They continue by stating that they are not putting any restrictions on the district court and that they are not providing any hint as to what result the district court ought to come to. Temporary injunction on pistol brace rule. The Fifth Circuit reached the decision that they think Judge O'Connor made a mistake when she denied the preliminary injunction that was initially asked by FBC. As a result, the court has decided to send the case back to the defendant so that he can reconsider the matter. The Fifth Circuit is of the opinion that the district court is in a better position to evaluate what kind of relief is required moving forward given the current circumstances.
And having to tell her that other 9-year-olds were just killed in a shooting is horrific.
And so when you keep going forward like this, it has to go through the 7 cycles of fire.
Get on the ground now!
I'm a federal agent.
917-110-3.
I'm a
federal agent.
Get on the ground!
Field background checks could stop a lot of illegal guns going in different places in the country.
Shall not be infringed, and the word infringe means by banning parts on firearms actually is against the Constitution.
In spite of this, the Fifth Circuit Court of Appeals has decided to keep their interim injunction in place for another 60 days. The purpose of this decision is to effectively preserve the status quo until Judge O'Connor makes a decision regarding the new injunction. This indicates that Judge O'Connor will have to make a decision on the injunction regarding the pistol brace within the next 60 days. However, the Fifth Circuit made it clear that they are not instructing Judge O'Connor how he must decide, what criteria he must apply to arrive at that judgment, or what kind of relief he must issue. They stated that they are just clarifying that they are not telling Judge O'Connor these things. They are, in effect, putting the issue back in his court by stating that even if they disagree with the way he initially ruled, they are going to leave it up to him to settle the matter nevertheless. If you are a member of FPC, GOA, SAF, or one of those organizations who had an injunction protecting their members with pistol braces,
brace that this letter was responsive to, are you telling me that this brace is exempt from your rule?
We are not finished. We are not finished. We are not finished.
Not one more! Not one more! Not one more!
The most serious readily provable offenses in cases where mandatory minimums are present because it's not warranted.
that protection is still in place, and according to the Fifth Circuit, it will remain for another 60 days. For those who are wondering what this means for them, the protection is still in place and will continue for another 60 days. Their injunction was left unaltered by the Fifth Circuit, and now it is up to Judge O'Connor to decide whether or not a national injunction should be issued, as well as how his injunction should be worded. The verdict is heartening since it reverses some of the ATF's overreach and finds that the ATF mishandled the issue and likely violated the APA. This is a win for the people who have been fighting against the ATF's overreach. The proposed rule deviated from the final rule in such a fundamental way that the proposed rule ought to be fully abandoned. Because of this, the situation is likely going to get more dynamic in the future. We are going to watch the ATF's response to this, as well as how the situation progresses in the years to come. That's all for this video, folks. We'll see you next time.